Ceann Comhairle, and could I too maybe echo the points that Deputy Wallace opened with. It's almost exactly a year since the government published the first Heads of Bill on a policing authority, and while this version is radically different and inferior, the one that we got last November wasn't any great shakes either. But that said, the fact that the government itself has on more than one occasion lauded this as one of your great achievements in government, and the fact that the Minister for Justice herself couldn't deign to be here, I find quite shocking, when she made about her 79th public appearance in welcoming in again for the 79th time the same-sex referendum result, which obviously everybody is happy about. We all voted for it, of course we were. That was a judgment of the people, and to milk it for the length of time and not have the time to come in here, I think, honestly, it's frankly shocking. But it's less shocking than what happened with the amendments. And to just register the point, we all like to work in a spirit of cooperation in here. But when members of the Justice Committee say that they cannot attend a meeting to discuss the amendments, and that committee goes on regardless, and then, you know, at lunchtime on the day these issues are being discussed, and let's remember, we got a note this morning with the grouping of the amendments tabled on this. There was no mention of anything being out of order on the first grouping that we got, but 2 hours later, after 12 o'clock, another grouping comes out to tell us that a chunk of amendments have been ruled out of order because they weren't discussed at committee, a committee which all of the opposition members made abundantly clear they were not in a position to attend that committee meeting. So the government put forward a bill that's supposed to be delivering transparency and accountability in policing, and does it in such an underhand manner, really sort of undermines your own argument. And unfortunately you will pay a heavy price for that, because we will absolutely insist on our democratic rights on every single amendment now being adhered to, whereas we might have been more amenable for speeding things up or whatever, any sense of cooperation. Why would it be given by the opposition when the government are so shameful in treating the opposition in that regard in committee stage? But I think to start on these issues, I mean, we are talking about a bill that's a much more diluted version of what she put forward in November of last year, and we were just looking at some of the information that we put out in this time last year, when we were making the point that the legislation then was substantially weaker than the legislation moved by Deputy Wallace and passed through second stage of this House, which you've allowed lie derelict. But that was and is a piece of legislation which delivers real Garda accountability and a Garda authority, a proper one that's independent, that was put together with major stakeholders such as the ICCL, the Irish Human Rights Commission, Combat Poverty, Social Justice, and all of the other organisations that have had an input, not least all of the countless people we've met the length and breadth of the country who've been crying and demanding justice in this area because of the difficulties they've had experienced at the hands of An Garda Síochána, and critically, members of An Garda Síochána themselves who found the structure incredibly inadequate in order to take forward grievances that they had. Now, the excuse put forward by the Minister the last time, and I've asked her about this and she's failed to answer it, is the reason why you have a watered-down version of what you were even talking about is because of legal constraints, constitutional issues, the advice, so-called, of the Attorney-General. Now, I honestly have to say, right, that when the history books are written about the record of this government, the role of the Attorney-General is going to feature. She's going to have at least a chapter or two on her own in terms of some of the things that she stood over. But with regards to this one, we don't know, because we've asked for the publication of that opinion and we haven't got it. But it rings very hollow, I have to say, on that, because that advice doesn't seem to stack up with the views being put forward by other people, because you're saying you had to roll back because of her advice, that you'd like something stronger and more robust, but the Constitution doesn't allow that. I don't think that's the case. In actual fact, most academics believe that the Garda Commissioner might actually be allied to the Executive under Bunreacht na hÉireann as it stands at the moment. And, you know, relying on the advice of the Attorney-General regarding constitutionality, well, publish it then. Let's see it. All it is advice, and as we said before, we know her advice has been wrong before. But if you really thought that it was wrong and there was a constitutional restriction to you making this bill better, well, why didn't you go and have a referendum on it? You were proposing, and you did, have one on the age of the President, which clearly nobody cared about at all. Why didn't you have something like this matched at the same time as the same-sex referendum? That would have been. So if you were worried about the Constitution, ye had the power to put that to the people, and they wouldn't have disappointed in that regard. Now, these sections relate to the issues of state security. And as Deputy Wallace said, we are unique in Ireland in our policing service because of the way in which security comes in under these issues as well. And as he said, there's no definition of state security in the Act. And in actual fact, our problem with these amendments is that what we're talking about in the bill, it's too broad. The Minister has been set up under this bill as basically judge and jury in relation to whether is a matter of national security or it isn't. And that isn't democratic accountability of An Garda Síochána. If the Minister can say, no, do you know what, you're not looking into that now because that's a matter for national security. And in essence, that's what's been put forward. Not only that, and I think Deputy Wallace has highlighted the actual protest actions that could be deemed to come in. The Minister might decide, look at what happens with the water charges protests this year. The amount of citizens who've been picked up for exercising a democratic right to protest, claims of people being put under kidnapping charges and all this ridiculous stuff, what anybody would see as lunacy, it's just not on. And the excuse of national security can be used almost without limit based on the way in which the government has drafted. And that's why we think it's very important to say who decides what is unlawful and where there's reasonable suspicion. Not just carte blanche that people can decide, but where there's reasonable submission. Now, I would put it as well, and I'd like the Minister to comment on the fact that the provision that's proposed in section 3A1A 2.3, whereby the Gardaí and the Minister decide whether something is unlawful. That surely has to be, without question, it must be almost certainly unconstitutional. Under the Constitution, only a court can decide whether something is unlawful or not. But this is saying that the Minister can decide whether something is unlawful. And to me, it's actually subverting parliamentary democracy. It seems absolutely lunacy. And the way it's defined there, actually, it could absolutely include things like water charges, protests over the installation of water meters and so on. And therefore, really what's been provided in this is the Minister is retaining full and direct control, and the authority really is having no role to play in policing issues that arise, because the Minister can turn around and say, no, authority, you're not looking at that, you can't see that because it's an issue of national security. And that is a huge flaw in this legislation. As Deputy Wallace said, it has been highlighted by many of the people who gave their opinion in the moving of this legislation. It's a big flaw in our mind. And again, the issue of an independent arbiter is something that we're putting up. I think it's in actually Amendment 3. To have a recourse, possibly to say a High Court judge or something of that character in this area. But the issue of national security is one of the overriding issues in the proposed legislation, and we do need to look at that. And a number of other options were put forward by some of the organisations that contributed to the discussion around this, and I think proper consideration could have been given to that. For example, the IHREC had no difficulty with issues of, say, national security policing being examined by either GSOC or overseen by the proposed authority, which is something that we would like, where national security policing impacts on the fundamental rights of individuals. The authority should also have a liaison role with any Oireachtas committee which has competence for national security policing review, as per the IHREC recommendation. They point out that this is a requirement of the European Court of Human Rights, that we have an independent body to provide oversight on national security policing. And we're putting forward, and we're discussing here tonight, a so-called independent Garda authority that does not have independent oversight in relation to national security policing. Instead, what we have is the government using this as a fig leaf or a big major wall to hide behind and to avoid public scrutiny, when actually ye had other options to deal with that. And in fairness, some of the academics who gave up their time and contributed to this process suggested other options. I mean, for example, Dr. Vicky Conway, in her presentation to Farm Lee, put forward the idea of two different approaches on security issues that she could have put forward, that she could have either transferred security matters to an alternative agency, as suggested by the Justice Committee, or the PBNI approach of removing these matters from the purview of the authority with some exceptional opportunities of review, some sort of a special purpose committee or so on. But I mean, the provisions that are there now, I mean, the protection of judicial oversight to the procedure which we're setting out in differentiating between policing and security matters is the absolute minimum. I mean, if you don't have that, you really have nothing. You're just saying the Minister can decide, that's it. You might as well wrap up and not have the authority at all. As an absolute minimum, a High Court judge is necessary there. So that's why we're putting forward the amendments at this stage. It is actually a key part of the bill, is the fact that in the Irish Police Service the two are so combined with each other, and if you're not prepared to disentangle them, well, there's actually nothing unlawful or nothing unconstitutional that couldn't provide you with given a break-up or more accountability in that regard. And I think it's really regrettable, because I've no doubt it's going to be used. And Deputy Wallace is correct to point to the opinions of people like Conor Brady, who we know is highly respected, former head of GSOC, who identified that the excuse of state security is a major obstacle to GSOC investigations into Garda Síochána, and we've no reason to believe that in the intervening years since he exited from GSOC that the situation has got any better. In actual fact, all evidence would say it's got worse, and some of the adjudications that GSOC have made as of late have diminished even further the confidence of the public in that organisation's ability to deal with Garda complaints and to hold the Gardaí to account. So if you've already got a problem with national security being used there in one Garda accountability body to set up a policing authority and to allow final decisions on what they can and cannot investigate at the door of the Minister, that's political policing and that's political interference. And it is not delivering genuine Garda accountability, and it's not the way forward. And in actual fact, you'd be better off doing nothing than going. It was the government that scheduled this debate. Minister Fitzgerald wasn't in Valletta yesterday. She was having another press conference on the same-sex referendum. We could have been in here discussing the Garda Authority Bill if that was her problem, and I think that's a very important point. You didn't respond on the issue of the Attorney General's opinion. I'd like to see it, because this is your official justification for watering down this bill. In essence, what's been proposed, if our amendments aren't adopted here, really is a continuance of government control over policing by denying the new Garda Authority a right to oversee events, by having the possibility of state security being used to block that. And I don't agree with the point that you make, that by us putting in where reasonable suspicion, that you're preventing the Gardaí or anybody else from being proactive in relation to matters. I mean, that's absolutely ludicrous. One would be imagining that if they are investigating people for issues, that they would have to have reasonable suspicion and not being just fishing and surfing for information on spec. For me, this should only be proactive based on reasonable suspicion, because privacy rights and civil rights are very important as well. And the key point we're making about unlawful is something is only unlawful or not under our Constitution if the courts deem it to be so. But the way in which the legislation is being put forward by the Minister and the Government at the moment is it's giving that power to interpret whether something is lawful or not to the Minister, which is outside her constitutional provision, and indeed is outside the way in which our Constitution works, which has a separation of powers, obviously, between the Oireachtas, the Government and the courts themselves. So this was just, we're trying to limit maybe some of the restrictions that you're putting in order to deliver greater accountability. I think they're imminently reasonable, and it's unfortunate that you haven't responded to many of the points that we have put forward.
Deputy Paul Bidlachlan.